Justice, and may it please the Court. California, as we've heard today, does not seriously contend that it can satisfy the First Amendment standards that apply to such a law. Instead, it's asking the Court to grant a free pass, a brand new Ginsburg-like exception to the First Amendment that would deny constitutional protection to some expressive works, not just video games, but books and movies as well, that describe or portray violence in a way that some court would hypothetically decide is offensive.
What was the state of the record that was present before the court in Ginsburg?
The state of the record was that they were aware of the sciences on both sides, but made judgment that is a matter of common sense.
So let me get this straight. The court acted on the basis of common sense. The difference between these video games and books and movies is that in these video games, the child is doing the actual killing. Will this affect the moral development of the child?
Well, Your Honor, it might. However, the state of California has not a shred of evidence that suggests that's true.
Now, I'm not an expert in psychology, but I think a legislature could have enough evidence to think there's harm in the idea of children pretending to torture helpless women and children with absurd weapons.
Well, there are various aspects of harm. The one I was about to address was the question of whether parents need additional help in exercising the role that they've played throughout history.
Come on, let's be honest. Any 13-year-old can bypass parental controls in about 5 minutes.
Parents are doing the purchasing 90% of the time. If not, the kids bring the video game home and the parent can review it. Also, the harm that is supposed to be inflicted is supposed to take place over a period of years, not minutes.
Now, on a side note, how much do these video games even cost? Not too many 13-year-olds walk in with a $50 bill, do they?
It seems very unlikely that people are buying video games without parental permission to begin with, and if they are, they're likely to be over 16 years old.
Mr. Smith, in all honesty, there is no tradition in this country of telling children they should watch people pour gasoline on others and then set them on fire. Does the First Amendment protect the sale of a video game like that to minors?
There is not a violence exception to the First Amendment for minors, nor should there be.
The question is that the First Amendment cannot say it's prohibited to sell a 10-year-old a video game in which they set helpless school children on fire. You seem to argue that there really is no good reason to think that exposure to video games is bad for minors. Is that right?
I don't think this type of expression is transforming children into murderers. Dr. Anderson, a psychologist that testified in the Illinois trial, states that the vast majority of children playing games will grow up to be normal, healthy, unharmed adults. He also acknowledged that the effects of these games are not different from watching cartoons on television or reading violent passages from the Bible.
Smith, how can you say there is nothing that can be done? There's plenty of proof that children are going into stores and buying these games despite the rating systems. And there's proof that some parents, as well-intentioned as they may be, have not been able to supervise that. So why are you arguing that there is no solution that the state could use to address this problem?
For several years, people have been trying to come up with a definition that would allow anybody to figure out which violent TV shows should be put into an adult category and which shouldn't. And they eventually gave up and realized that they have no idea how to do that. There's no system of deciding whether a game is 17-year-old appropriate or 18-year-old appropriate. The line is too fine. How can we develop a system, like one a congressman suggested, of making a rating system for ages? The difference between them is too gray. There's not much we can do. The question before this court is whether you're going to create an entirely new exception under the First Amendment.
This morning we will hear the first oral argument in case 08-1448.
And may it please the court. The California state law at issue today is relative to Ginsburg v. New York, different in only one respect. Where Ginsburg dealt with minors' access to harmful sexual material, California is concerning itself with minors' access to the deviant level of violence that is apparent in certain video games, which is just as harmful to the development of minors. This rule, like Ginsburg, allows parents to have authority in their own household to better direct the upbringing and guide the development of their own children. Next, this rule advocates for the state's independent interest in helping parents protect the well-being of their children in these circumstances, especially because parents are generally not present while their children play the video games.
Quickly, can you better define deviant? How does a deviant violent video game differ from a normal violent video game? Is there any established normal in violence?
Well, Your Honor,
I just don't see how you can cut off violence at video games. What about movies, comic books? Will this principle extend beyond video games and include violent materials of any form?
No, Your Honor. That is why we have created the 3 prongs of the Miller Standard. Therefore, It will be violence that meets all three terms set in the Miller Standard, not just deviant violence or offensive violence.
The original question was, why just video games, not movies?
Of course, Your Honor. Well, the California State Legislature has been presented with evidence to conclude that the interactive aspect of video games, violent ones in specific, where the minor is the aggressor, the one acting out the harmful level of violence, is more detrimental to the moral development of the young adult.
I believe the statute at hand is vague. My question is this. For generations, sexual material have been present in society, and there is a societal consensus for what is appropriate and what is offensive. And forever there have been judicial discussions on it, but they are all vague. I think you need to know that right now you have no consensus or precedent on violence in video games. What you are asking of us is to entertain a topic that has no previous consensus or judicial opinions.
Your Honor, I am fully aware that there has been no previous consensus or precedent on violence. That is why we must start somewhere, and California desires to start now. We must build a standard for what is appropriate of video game violence. I believe that looking at the historic statutes in relation to monitoring sexual material, in Gibson v. New York, for example, identifies that there has previously been an issue with the level of obscene material presented in a society.
Okay now, based on your brief, am I correct in understanding that the state of California has given up the idea that this law protects the interest in preventing minors who are exposed to these video games from going out and committing the violent acts that appear before them? Rather, the state's main focus is in protecting the general moral development of the children?
Yes, exactly. That is the primary interest of the law at hand, to regulate the internal harm to minors. That is what California is concerned with, in hopes of creating somewhat of a ripple effect to ensure a safer society as generations go on.
So if the parent buys the game, is that acceptable?
Yes. Each parent is entitled to the right to decide how to raise their child in the manner they deem appropriate. The parent may involve themselves in this decision. This is a law to help the parents.
Okay, thank you.
This standard is essentially telling manufacturers and distributors to evaluate the material and judge for themselves whether or not the level of violence meets the prongs of this definition.
The district court and the appellate court both said that the requirement of labeling each video game in a certain way, as well as classifying the selling of violent video games to a minor as a crime, was unconstitutional, correct?
Correct. But the Constitution had not foreseen violent video games and their effects on the moral development of children. It is necessary to understand that when Madison constructed the Constitution, he was unable to consider the future technological advancements.
I believe that is not where the question lies.
If I could reserve the remainder of my time.
Thank you, Mr. Morazzini.
Thank you.
Schwarzenegger v. the Entertainment Merchants Association was appealed from the United States Courts of Appeals for the Ninth Circuit on February 20, 2009. The oral arguments were heard November 2, 2010. Still lingering today, in end, the Supreme Court's decision will affect the extent of minors' constitutional rights, the power of states to control which materials children are exposed to, and the expression of media with violent content.